Okay, well, we are ready. Today, I think everybody knows, is the last day of our summer program, and we will be sending emails soon with the fall program. It starts September 21st. And I hope you invite your friends and neighbors to join. It will again be all on Zoom. We're hoping to go back to combination of person and line in the winter, but fall is definitely all online. And we will be having an outing at the Frick Museum, a virtual tour coming up on August 9th. So keep your eye on email. There'll be a lot of information about both going out early next week. Anyway, here we are. Leora has a lot to tell us today, she just said, as she always does. So Leora, over to you.
Okay, today, of course, I'm going to talk about John Roberts. But I forgot to mention one piece of trivia that I learned about Rehnquist last week. So I'm going to start with that. And in some ways, it's a kind of an appropriate transition because John Roberts was a law clerk to Rehnquist in the 1980-81 Supreme Court term when Rehnquist was an associate justice. Anyway, this comes from the Stanford Law Review, which back in 2010 published a tribute to Rehnquist that was written by a Stanford faculty member, someone named Barton Thompson, who had also clerked for Rehnquist. And Barton Thompson wrote as follows. The chief loved geographic and historical facts. Part of this love was his enjoyment of fact games, which in turn was part of the chief's love of games in general. The chief relished matching his own memory against the knowledge of family, friends, and clerks. Any attempt to describe the chief without mentioning his enthusiasm for fact games would be like trying to describe Babe Ruth without mentioning his skill at hitting home runs. At the chief's funeral, his younger daughter, Nancy Rehnquist Spears, recounted how early one summer, the chief bet her $5 that she could not name the year when Queen Elizabeth I had died. Having just finished a biography of the Virgin Queen, Nancy readily spouted off the answer of 1603. The chief quietly cursed and spent the rest of the summer trying to win back the $5. Every year, the Rehnquist clerks would hold a reunion, at which the current clerks had to present a skit focused on the chief and the Supreme Court term for the benefit of their predecessors. And I'll just say that this is quite common as a form of reunion by the clerks for various justices. Anyway, he goes on to say, the game show Jeopardy provided a thematic structure for a number of these skits, with the chief cast in the role of Art Fleming, dating himself, trying to stump his fellow justices or others with oblique questions about the Supreme Court, U.S. geography, and history. I had to include that because I'm a big Jeopardy fan. Okay, so now I'm going to turn to John Roberts and how he came to be the 17th Chief Justice of the United States Supreme Court when he was sworn in on September 29th, 2005. So his full name is John Glover Roberts Jr. And he was born January 27th, 1955. So he's now 66 years old, practically a youngster. And that answers a question that I was asked last week, but didn't remember the answer to then. He was born in Buffalo, New York, so he's a native New Yorker, not New York City, and his family is Welsh, Czech, and Irish, with the Irish part being the most important, as you'll see as his story unfolds. He has three sisters and one older and two younger. He's the only boy in the family. His father started out as an electrical engineer who worked for Bethlehem Steel. While Roberts was in elementary school, his father was promoted to be a plant manager with the company. And the family moved to Long Beach, Indiana for his new position. And Roberts attended Catholic schools in Indiana, and for high school, he went to a place called La Lumiere, which is, I've looked them up on the internet, still a highly rated Catholic college prep boarding and day school. And it was about 30 minutes from his home. Not surprisingly, Roberts was an outstanding high school student. He graduated first in his class. He was also co-editor of the school newspaper. He was a member of the choir. He was co-captain of the football team. And he was also a regional wrestling champion. His academic record allowed him to attend Harvard and to begin college with sophomore standing. While he was an undergraduate there, he earned a prize for the most outstanding essay by a sophomore history major. And that was actually in his first year of college because he was treated as a sophomore, as well as a prize for his senior paper. During the summers, he worked at the steel plant managed by his father. He graduated summa cum laude in 3 years, majoring in history. And like Rehnquist, his original plan was to earn a PhD and become a professor. But he changed his mind and instead went to Harvard Law School. At law school, he was the managing editor of the Law Review, and he graduated magna cum laude in 1979. After law school, he first clerked for Judge Henry Friendly of the U.S. Court of Appeals for the Second Circuit in New York City, a very highly regarded federal judge, in fact, someone who many people think should have been appointed to a Supreme Court position, but never was. The next year, he clerked for Associate Justice William Rehnquist, the man who would go on to become Roberts' predecessor as Chief Justice. It's pretty easy to see why Rehnquist picked Roberts as a law clerk. They had both grown up in the Midwest, but they had left home to attend similar elite institutions for their undergraduate and law degrees, and they both had outstanding academic records at those schools. Clerking for Rehnquist was apparently a formative experience for Roberts, and a Harvard law professor and legal historian, a man named Morton Horowitz, has described Roberts when he knew him as, quote, a conservative looking for a conservative ideology in American history. And Roberts first found that ideology when he clerked for Rehnquist. 2 years before the Federalist Society was even formed, which was in 1982, Rehnquist's office at the Supreme Court was an informal Federalist Society, and it was a place where conservative legal views were very popular. Rehnquist's views influenced and reinforced Roberts' views. And a man named Paul Smith, who knew Roberts in college and who clerked for Powell at the same time as Roberts clerked for Rehnquist, has said about Rehnquist and his influence on Roberts, Rehnquist reinforced John's pre-existing philosophies. John was not a believer in the courts giving rights to minorities and the downtrodden, and that was the basic Rehnquist philosophy. After his clerkship ended, and undoubtedly, at least in part due to his clerkship, Roberts worked in the Reagan administration. He first worked in the Justice Department from 81 to 82 as a special assistant to Attorney General William French Smith. His immediate supervisor there was Ken Starr, as we all remember, or a man who we all remember, who was then the counselor to the Attorney General. The Justice Department was at that time the heartbeat of the conservative legal movement. That was a core component, of course, of the Reagan presidency. And after he started work at the Justice Department, Rehnquist wrote a letter to Judge Friendly, who he had clerked for in the Second Circuit. And he said in the letter, This is an exciting time to be at the Justice Department. So much that has been taken for granted for so long is being seriously reconsidered. So Robert's next assignment was as associate counsel in the White House counsel's office from 82 to 86. In 86, he left government, at least for the moment, and took a job with a law firm in Washington, D.C. named Hogan and Hartson. In 89, he returned to the government, and this time George H.W. Bush was president, and he served as the principal deputy solicitor general for the Justice Department. And that was the second time that he worked for Ken Starr, who was at that time the Solicitor General in the Bush administration. When the Solicitor General had a conflict of interest, Roberts represented the government in a case involving a challenge to the policy of the Federal Communications Commission to provide preferences in awarding broadcast licenses to minorities. And Roberts made the decision to argue that the agency policy violated the Constitution because racial preferences are unconstitutional. And that is a position that he has continued to support all these years later throughout his time on the court. On January 27th, 1992, while he was serving in the Solicitor General's office, President Bush nominated him for a seat on the Court of Appeals for the District of Columbia Circuit. But there was no vote taken on his nomination. And this wasn't anything specifically to do with Roberts, but a more general issue. Roberts was among a number of nominations that Bush made during 1992, which was an election year. And then Senate Majority Leader, then Senator Biden, who was, he wasn't the majority leader, he was the chair of the Senate Judiciary Committee at that point. And he refused to hold hearings on any of these nominees. So Roberts' nomination died in committee and the president withdrew it on October 8th, 1992. It was during his time at the Solicitor General's office that Roberts met Jane Sullivan, his future wife. And they met in 1991 at a beach house in Delaware that was jointly rented for the summer by a group of lawyers from a number of different law firms. He had only a brief meeting with Jane at that point, who was at that time and still was a lawyer also, and because she was scheduled to soon move to Australia for a year to work for a leading Australian law firm. After she returned from Australia, they met again in 1993, and this time the relationship developed fairly quickly, and they married in 1996 when they were both 41 years old. And a few years later, in 2000, they adopted their two children, who were both born in Ireland, and their names are Jack and Josie, and they are now both in college. I'm going to talk about more about Jane Roberts before returning to John Roberts' career path to the Supreme Court, because she marks a departure from the wives of earlier Supreme Court justices, chief justices. She had her own high-powered legal career before her marriage, and she continued with her career after her marriage, although, as is often the case, she made several sacrifices to raise a family and also to accommodate her husband's career. Her parents were both Irish, and her mother actually emigrated from Ireland. And like her husband's family, her parents had 4 children, the 3 girls and a boy. Her family wasn't wealthy, but they were very Irish and very Catholic, and they lived in a close-knit community in the Bronx. She was also a distant cousin of Eugene O'Neill. After graduating from the College of Holy Cross, where she went to college, and she was in the first class that admitted women. She earned, after that, a diploma of education at the University of Melbourne, and in Australia, and later a master's degree in applied mathematics from Brown University. She then taught mathematics, and she then worked as a systems engineer at Bell Laboratories. And at that point, she switched her career path and went to Georgetown Law School. And she graduated in 1984 from law school. And after graduating, she spent a year as a law clerk for a judge on the Court of Appeals for the Fourth Circuit. And after that, she took a job with a large law firm in Washington, D.C. It's currently known as the Pillsbury Law Firm. And she worked as a litigator initially for that firm. And it was during her time as a litigator at Pillsbury that she first met John Roberts, and then went and spent that year in Australia. When she returned, she went on to become a partner in the global technology group at the law firm. But after they adopted their children and John Roberts became a judge, she switched her focus at the law firm, and she became the executive partner for talent development, as well as working only part-time beginning in 2003. In 2007, she made another change in her career, this time to avoid any potential conflicts of interest between the work done by her law firm and cases before the United States Supreme Court. She left the firm as a result, and she joined a legal recruiting firm. In 2019, she was hired by something called the M Legal Group, which is now called McRae, which is another legal recruiting firm, and she was hired to be in charge of the company's opening of an office in Washington, D.C., and she now is the managing partner of that office. And what she does in that job is apparently she advises law firms on succession planning as their lead partners age. She advises partners in groups within firms on lateral moves, and also government attorneys who want to transition to the private sector. She and John Roberts have two vacation homes, one in Maine and the other in Limerick County, Ireland, near where her mother grew up. But otherwise, they live apparently a very unassuming life, and they stay out of the public spotlight. And you can tell this by how few photos there are on the internet that show the Roberts attending any sort of an event that doesn't have anything to do with the United States Supreme Court, as well as the absence of any family photos once the children, were when the children were growing up, other than when they were quite young. Jane Roberts has long considered herself to be a feminist, including back when she was in college. And she is also an abortion opponent. And these two positions merge in her lifelong work starting in 1995 before her marriage, first as a board member and then as a pro bono legal advisor to an organization called Feminists for Life. And I looked at the organization's website, and they describe the views of the organization this way. They say, abortion is a reflection that our society has failed to meet the needs of women. We are dedicated to systematically eliminating the root causes that drive women to abortion, primarily lack of practical resources and support, through holistic, women-centered solutions. Women deserve better than abortions. I include this because it comes up a little later again. So now I'm going to return to John Roberts. So after Clinton was elected president in 1992, Roberts returned to Hogan and Hartson and became head of the appellate litigation group at the firm. And he remained at the firm for 10 years. And he was a very outstanding appellate litigator. And during his time at the firm, he argued 39 cases before the United States Supreme Court, and he won 25 of them. While his law practice, like most large law firms, was politically neutral, he was briefly involved with the contested 2000 presidential election. He traveled to Florida to advise Florida's then Governor Jeb Bush on his legal responsibilities under federal law in a contested presidential election, and he helped Bush's legal team to prep for an oral argument. Roberts finally became a federal judge in 2003 when he was appointed by President George W. Bush to the Court of Appeals for the DC Circuit. He served on that court for only 2 years. On July 1st, 2005, Sandra Day O'Connor announced she was retiring, effective when her successor was confirmed. And shortly after that, President Bush nominated John Roberts to replace O'Connor as an associate justice. But on September 3rd, before Roberts was confirmed, Chief Justice Rehnquist died suddenly, or not too suddenly, because he had cancer for some period of time, but he died. And several days later, the president withdrew Roberts' nomination. And at the same time, he nominated Roberts to be Chief Justice. So timing is everything. Some minor controversies arose during his confirmation hearings, including the issue of his wife's work for Feminists for Life, which some liberal Democrats, including Ted Kennedy, said should be out of bounds. There was also a dispute over whether he had formally been a member of the Federalist Society or not. There was some criticism, actually, of members of the Judiciary Committee because some members asked questions about Roberts' Catholic faith. And there was also a small controversy over Roberts' role in the 2000 election. But the hearings really showed Roberts' enormous skill at answering questions and are probably actually best known for Roberts' opening statement, where he compared a judge to an umpire. And he said specifically, judges and justices are servants of the law, not the other way around. Judges are like umpires. Umpires don't make the rules, they apply them. The role of an umpire and a judge is critical. They make sure everybody plays by the rules, but it is a limited role. Nobody ever went to a ball game to see the umpire. I have no agenda, but I do have a commitment. If I am confirmed, I will confront every case with an open mind. I will fully and fairly analyze the legal arguments that are presented. I will be open to the considered views of my colleagues on the bench, and I will decide every case based on the record according to the rule of law without fear or favor, to the best of my ability. And I will remember that it's my job to call balls and strikes and not to pitch or bat. Roberts was fairly quickly confirmed on September 29th by a vote of 78 to 22, with 22 Democrats voting in favor of his confirmation. He was sworn in the same day, and therefore the original Roberts Court consists of Associate Justices Stevens, O'Connor, who had not yet been replaced, Scalia, Kennedy, Souter, Ginsburg, and Breyer. Several days after Roberts' confirmation, however, Bush nominated White House counsel Harriet Miers to replace O'Connor. But on October 27th, Miers asked the president to withdraw her nomination after it became clear that many members of the Judiciary Committee viewed her as lacking even basic knowledge of constitutional law. So on October 31st, President Bush instead nominated Samuel Alito to the court. And Alito was confirmed on January 31st, 2006, and sworn in that same day. The Senate vote was quite different than in Roberts' case. It was 52 to 48, with only 4 Democrats voting in favor. The vote by the Democrats was a reflection of the prediction that Alito would move the court to the right. So now that I've talked about everything through that kind of early period, I'm going to share some photos, as I've done before, of Roberts in his early days before the court. And no, I don't want to do this. Hold on. Let's try again. Here we go. Okay. So this is Roberts in 1983 when he was serving in the White House counsel's office. Quite young John Roberts, as Judy pointed out to me, when he was still wearing glasses, I guess before, must be pre-contacts, unless we should imagine that his eyes miraculously cleared, became 20/20, but I suspect not. Then we have a photo of John and Jane Roberts at their wedding. This photo was published in Irish America magazine, which has carried a number of stories about the Robertses. So here they are, the young, relatively young couple. This is Roberts being sworn in to the court as Chief Justice. Justice Stevens did the swearing in. This is his wife, Jane, holding the Bible, and President Bush looks on. This is Roberts and his family, including his 2 young children, on October 3rd, 2005, which was when Roberts first took his seat on the court. So here they are. Jack and Josie, and John and Jane. A lot of J names. This is Roberts in his early official photo as Chief Justice. Smiling. Guess he's glad to be there. This is the Roberts Court in 2005, while Sandra Day O'Connor was still a member of the court. Roberts and Stevens and Sandra Day O'Connor and Scalia and Kennedy, and in the back row, the most junior justices, Souter, Thomas, Ginsburg, and Breyer. And then finally, this is the court between 2006, here we go, and 2009, after Alito joins the court, replacing Sandra Day O'Connor. The rest of the membership remains the same, but here's Alito in the back row, much taller than Justice Ginsburg, who he's standing next to. Okay, so I'll come back to some later photos a little later on. So after Alito replaced O'Connor, the next 2 changes in the court's membership came when Obama was president. In 2009, Souter resigned and was replaced by Sonia Sotomayor. The next longtime member of the court to resign was John Paul Stevens, who resigned in 2010 and was replaced by Elena Kagan. Neither of those changes brought about any kind of major change in the court's ideological balance. and left Justice Kennedy as the swing justice, mainly voting with the conservatives, but not on several important issues. As we all remember, the next vacancy didn't come until 2016 when Scalia died unexpectedly on February 13th. And his death left the court with a 4-4 liberal conservative balance. And not to upset that balance too much, Barack Obama nominated Merrick Garland, who was known as a moderate, to replace Scalia. But McConnell, who was then Senate Majority Leader, refused to allow the Judiciary Committee to hold a hearing to consider Garland's nomination, so that the court vacancy remained unfilled until after Trump was inaugurated. And on January 31st, 2017, Trump nominated Neil Gorsuch to replace Scalia. On April 3rd, the Judiciary Committee approved his nomination with a party line vote. But on April 6th, the Democrats filibustered the nomination, which caused the Republicans to use the so-called nuclear option to eliminate the filibuster for Supreme Court appointments and allow a Supreme Court nominee to be confirmed by a majority vote. Which wasn't, what then happened. Gorsuch was confirmed on April 7th, the next day, by a vote of 54-45, with only 3 Democrats voting in his favor. The next change came a year later when Kennedy announced at the end of June that he was resigning effective the end of July. On July 9th, President Trump nominated Brett Kavanaugh to fill his seat. And Kavanaugh was confirmed after a very controversial Senate confirmation process that included allegations that Kavanaugh had been guilty of sexually assaulting Christine Blasey Ford when they were in high school. And the proceedings, the Senate proceedings, were a kind of eerie reminder of Anita Hill's allegations against Clarence Thomas. And Kavanaugh's statement during the hearing about the charges against him was very reminiscent of Thomas's statement in his case. And Kavanaugh said about this, this confirmation process has become a national disgrace. You have replaced advice and consent with search and destroy. And that was pretty similar to Thomas's use of the phrase high-tech lynching in his confirmation hearing. The outcome of the confirmation battle, like in the case of Clarence Thomas, was that Kavanaugh was confirmed. The vote was 50-48, with only 1 Democrat, any guesses who, voting with the Republicans. The Democrat who voted for him was Joe Manchin. Anyway, Kavanaugh was sworn in October 6, 2018. And then the final change in the court's membership came, of course, as a result of Ruth Bader Ginsburg's death on September 18th last year, shortly before the 2020 presidential election. And of course, McConnell defied and Trump defied historical practice of not filling Supreme Court vacancies right before an election. And Trump went ahead and nominated Amy Coney Barrett very shortly after Ginsburg's death, and McConnell rushed her confirmation through the Senate so that she was confirmed on October 26th by a vote of 52-48 without a single Democrat. So the number keeps drifting down, 4-3, and now we're at 0, 4-3-1-0, I think is how it goes. So without a single vote from Democrats, and that was the first time since 1870 that a Supreme Court justice has not gotten a single vote from the minority party. One other first, which reflects the extreme partisan divide, is that this is the first time in US history that the president and vice president, the current president and vice president together, have voted not to confirm a majority of the justices on the court, with Biden having voted against Roberts, Thomas, and Alito while he was in the Senate, and Harris, when she was a senator, having voted against Gorsuch, Kavanaugh, and Barrett. It's hard to imagine that any other Chief Justice has led a court where there have been so many fierce confirmation battles. Okay, so now that I've reviewed everything that's happened up until the present in terms of the composition of the Roberts Court, I'll share the remaining pictures. Okay, so here we go in 2009 to 2010, when Sonia Sotomayor joins the court, replacing Justice Souter. And now we have two women on the court, back on the court, since that was also true when Ruth Bader Ginsburg and Sandra Day O'Connor were both on the court. And then this is the court in a time of relative stability between 2010 and 2016, when Elena Kagan replaced John Paul Stevens, and Ruth Bader Ginsburg gets to move into the front row in terms of seniority. And here we have a series of pictures during these much more turbulent recent years, starting with 2017 to 2018. So here's a picture of the court back then when Gorsuch joins the court, taking the seat that Merrick Garland was originally nominated for. And here we have 2018 to 2020, when Kavanaugh joins the court, and you can see the conservative liberal balance kind of starting to shift, and that kind of culminates with the current court. Picture of the current court where Amy Coney Barrett has joined the court, and the court now has 6 conservative members of the court and only 3 liberals remaining on the court. Okay, so that's the court to date, although there will probably be more changes in the continuation of Roberts' time as Chief Justice. With all of the changes in the court's membership, including Trump's 3 appointments, unlike the fairly stable membership of the court while Rehnquist was Chief Justice, the Roberts Court has, of course, had a number of critical changes in its membership. And that was particularly true of the losses, first of O'Connor, replaced as she was by Alito, then the loss of a much more conservative justice, then the loss of Kennedy, replaced by Kavanaugh, and finally the dramatic change between Ginsburg and Barrett. Probably the most dramatic of all the changes, although it's so early in Barrett's time on the court that we really haven't seen how that exactly will play out. Those changes, of course, have had an impact on the court's decisions, moving them in a more conservative direction. But I think it's more that's likely that the impact of those changes will be even greater in the upcoming term of the court and beyond than they have been to date. So with that, look at the changes in the associate justices during Roberts' time on the court. I'm going to turn to John Roberts and his leadership of the Supreme Court. So Roberts has been described by many as believing in judicial minimalism in his decisions, which is to say, deciding only what is absolutely necessary to reach a decision in a case and no more. And he's done that in a number of very important cases in his time as chief. His central focus as Chief Justice has been to preserve the court's legitimacy as against charges that the court has become very partisan, as well as trying to preserve its independence from the other branches of the federal government. His support for the integrity of the court was made pretty obvious when he responded to a comment made by President Trump in 2018, when Trump described a particular federal judge as an Obama judge. And Roberts at the time made a public response, and he said, "We do not have Obama judges or Trump judges, Bush judges or Clinton judges. What we have is an extraordinary group of dedicated judges doing their level best to do equal right to those appearing before them." Two other challenges that Roberts has faced recently during his time as chief are first presiding over Trump's first impeachment trial from January 16th till February 5th of 2020. And the second difficulty is the pandemic, which caused the work of the court to be done differently, including oral arguments using a conference call system, which in fact encouraged Clarence Thomas to play a major role in the arguments for the first time. Nobody knows, because it hasn't been announced, whether the court will go back to in-person arguments in the fall or not, and they're probably going to wait till closer to the start of the new term before they make that decision in light of what's going on now with the Delta variant. So I'm now going to focus on a chronology of the major decisions while John Roberts has been Chief Justice, and there have been many of them. And maybe more than in the previous cases, because they're so recent that they seem more memorable, but it was hard to even choose among them sometimes as to which was the most important. I'm going to do this, as I said, in chronology, and I'm going to start with three cases decided during Roberts' first year as chief. There was a major decision early in that year in a case called Rumsfeld versus Fair. It was a First Amendment case in which Roberts wrote the opinion for a unanimous court. The case upheld a provision that was called the Solomon Amendment, which allowed the federal government to withhold funding for universities if the universities refused to allow military recruiters to recruit on campus. The universities argued that as a result of that policy, they were being compelled to support the military's don't ask, don't tell policy that barred openly gay and lesbian members of the military. But the court rejected the argument and concluded that allowing on-campus recruiting didn't express support from the military policy. And didn't prevent universities from expressing their disagreement with the policy in myriad other ways. The decision was one of the rare times, maybe the only time, when the Roberts court has rejected a compelled expression argument. Another early free speech decision that year severely restricted the rights of government employees to engage in expression. It's a case called Garcetti versus Sabalos. It was a 5-4 decision, and Kennedy wrote for the conservatives on the court, including Roberts, and the court limited prior rulings recognizing that government employees have free speech rights by carving out a fairly broad exception for cases where the speech at issue was a part of the employee's official duties. A third case was Randall versus Sorrell. It was the first of a series of cases where the Roberts Court has limited the ability of the government to restrict campaign spending and contributions. In Randall, by a vote of 6-3, the court struck down a Vermont law that limited the amount of amount that campaigns could spend, as well as imposing strict limits on campaign contributions. The court invalidated both aspects of the law. It didn't overturn the court's decision in 1976 in Buckley versus Vallejo, where they had upheld limits on campaign contributions, but it was very divided in its reasoning. Breyer wrote a plurality opinion, joined in full by Roberts and in part by Alito, and Kennedy, Alito, and Thomas each wrote concurring opinions, with Scalia joining Thomas's concurring opinion. So a number of different views expressed to justify this decision, but nevertheless, both provisions were struck down. The following term, the important cases were cases involving abortion and affirmative rights, affirmative action. The abortion case was a case called Gonzalez versus Carhart, a 5-4 decision which upheld a federal law called a partial birth abortion ban, with Kennedy writing the opinion for the conservative wing of the court. Kennedy applied the undue burden test that the court had adopted in 1992 in Planned Parenthood versus Casey, but in her dissent, Justice Ginsburg called the decision alarming and one that refused, in her view, to take Casey seriously. The affirmative action case was a case called Parents Involved in Community Schools versus Seattle School District. Unlike previous affirmative action cases, as well as affirmative action cases decided up until the present, this was the only case that involved K through 12 public education rather than university admissions. And at issue in the case were efforts at a voluntary school desegregation and integration in Seattle and Louisville, Kentucky, that used the existing racial composition of each school as part of the criteria used to assign students to particular schools. And Justice Kennedy was the crucial swing vote in the case. He agreed with the 4 conservative justices that the plans adopted by the 2 school districts were unconstitutional because they weren't narrowly tailored, and race controlled pupil assignment in a number of situations. But he also agreed with the 4 liberals that the school district's efforts to avoid racial isolation and promote diversity and avoid resegregation of the schools based on factors like housing patterns were compelling interests, and that the districts could work to achieve those objectives by other means. So he partly agreed with the liberals and partly agreed with the conservatives, and the other piece of that is, of course, Roberts agreed fully with the conservatives that there was no compelling interest for what the school districts were doing, and also the use of using an unconstitutional means. Although that's less important than the part of the decision that took the view that there was no compelling interest. Because the consequence of that is it doesn't matter how they do it, they can't do it. By far the most important decision in 2008 was District of Columbia versus Heller, which was a very controversial 5-4 decision with an opinion by Justice Scalia that for the first time in the history of the court ruled that the Second Amendment protects an individual right to possess a firearm for purposes of self-defense in the home. Scalia's originalist jurisprudence was strained in Heller, to say the least, since he had to explain away some of the specific language of the amendment, as well as the reasons the framers included the amendment in the Bill of Rights. Justice Scalia said about the decision that it was unquestionably Justice Stevens, I hope I said that, called Heller unquestionably the most clearly incorrect decision that the Supreme Court announced during my tenure on the bench. And since he served on the court for 35 years, that's saying something. Heller was followed up in 2010 by McDonald versus City of Chicago with the same 5-4 vote division. McDonald ruled that the Second Amendment was incorporated into the 14th Amendment due process clause and was therefore applicable to the states as well as to the federal government. Next term, the court's going to decide another Second Amendment case challenging a New York restriction on gun ownership. That case is likely for the first time to make clearer the extent to which the government is allowed to regulate gun ownership and use, something that the earlier cases were fairly vague about. Even though they struck down the regulations at issue. Over the next 2 years, from 2008 to 2010, by far the most important decision was Citizens United versus Federal Election Commission in 2010. Once again, a 5-4 opinion with Justice Kennedy writing for the majority. The case struck down provisions of the Bipartisan Campaign Reform Act, which regulated independent expenditures during political campaigns by corporations, unions, and nonprofit entities on the ground that it violated First Amendment freedom of speech rights. The case opened the door to unlimited spending in election campaigns. And while the expenditures are at issue are supposed to be independent and not coordinate with the candidate's campaign, that's a limit that's hard to enforce. And that even assumes that we have an FEC that's trying to enforce it. And even without coordination, it's fairly easy to identify ways in which independent expenditures can further spread a campaign's core message, or in some cases, actually spread effectively communicate a message that the campaign itself is reluctant to be associated with, but is glad that someone else is spreading on its behalf. There were several other important cases decided the same year as Citizens United, but they really took a back seat to the Citizens United decision. One of them was Padilla versus Kentucky, which was another 5-4 decision. This time, Kennedy joined an opinion written by Justice Stevens that held that the Sixth Amendment right to counsel required that the attorney for a non-citizen criminal defendant had to inform their client if a guilty plea entered as part of a plea agreement will or even might result in the client's deportation. There was also an important free speech case, United States versus Stevens, which struck down a federal ban on depictions on animal cruelty. The government unsuccessfully argued that depictions of animal cruelty were an unprotected category of speech that the government could regulate free of any First Amendment restrictions. In an 8-1 decision with an opinion by Chief Justice Roberts and only Alito dissenting, the court rejected the government's argument. The important part of its reasoning was that it reinterpreted the reasons why a particular category of speech is unprotected. It moved away from reasoning that the speech had limited value under the First Amendment and instead focused on whether the category had been historically unprotected. Finally, there was McDonald versus City of Chicago, the case I mentioned earlier, that applied the Second Amendment to the states. In the 2010 term, which was the first term with Justice Kagan on the court decided 2 First Amendment cases. One was a second case rejecting an argument that the category of speech was unprotected. This time, the category of violent video games. The second case was a case where Chief Justice Roberts wrote the majority opinion, and once again, only Alito dissented. It's a case called Snyder versus Phelps. It involved picketing by members of the Westboro Baptist Church at the funeral of a Marine, and the picket signs said things like, thank God for dead soldiers and God hates fags. The soldier's family filed a lawsuit for intentional infliction of emotional distress, but the court held that the First Amendment protected the speech at issue, which involved, in Roberts' view, and the court's view, a matter of public concern, and therefore the jury verdict in the family's favor was overturned. From 2012 until 2016, the court's membership remained the same, and its decisions over those years showed the same combination of liberal and conservative victories. By far the most controversial decision in 2012 was National Federation of Independent Business versus Sebelius. That was the 5-4 decision written by Chief Justice Roberts, where the court upheld most of the provisions of the Affordable Care Act, including the individual mandate requiring the purchase of health insurance. The mandate was upheld as an exercise of Congress's power to tax, since it was enforced by a tax penalty, and that decision was thanks to Chief Justice Roberts joining the liberals on that part of their analysis. Roberts, however, joined the conservatives in other parts of the decision, where Kennedy included, reached the decision that the law couldn't be upheld as a valid exercise of the regulation of interstate commerce. Roberts also agreed with the conservatives that the provision requiring states to comply with the Medicaid expansion part of the law to help people pay for coverage was unconstitutional. Because he found a way to uphold the central provisions of the law by using the taxing power, the case caused conservatives to be very critical of Roberts. And that criticism has actually continued to the present because they don't really view him as a true believer, one of them. This term, there was a new challenge to the ACA, which was brought as a result of Congress's action ending the tax penalty. The lawsuit argued that without any tax consequences, the law could no longer be considered a tax and therefore was unconstitutional. In California versus Texas, by a vote of 7-2, in an opinion by Justice Breyer, joined by all the members of the court except Alito and Gorsuch, the court didn't reach the merits of the dispute and dismissed the challenge on the ground that the states and individuals bringing the lawsuit lacked standing to challenge the law since they couldn't show that they were harmed by the elimination of the tax penalty. That same year, the court also upheld a third case in this trilogy of cases restricting government arguments or rejecting government arguments that category of speech was unprotected. In the Alvarez decision, the court struck down part of a federal law that made it a crime to make a false statement about having a military medal. The court refused to recognize that false speech was a category that received no free speech protection, something that plays out in our current controversy over the spread of false information. This time, Alito's dissent gained a few more adherents, Scalia and Thomas. The next year, 2013, there were two pretty dramatic decisions, one conservative and one liberal decision. In Shelby County versus Holder, a 5-4 decision with Roberts writing for the majority, the court struck down a key provision of the Voting Rights Act, invalidated the so-called coverage formula, which was used to identify states and counties that had to obtain pre-clearance from the Justice Department or a federal district court in order to change their voting laws. As a result of invalidating the formula, the pre-clearance process became unenforceable as a way to prevent racial discrimination in state voting laws, and that explains why all of these states are now able to make all of these changes in their to restrict voting without having to go through that process. While the decision only relied specifically on the fact that the pre-clearance formula in the current law was outdated, the Roberts opinion does suggest that Section 5 may well be unconstitutional, even with an updated formula. But Roberts didn't have to reach that issue specifically or decide that issue specifically in the Shelby County case. We don't know for sure. But it does suggest some risks if the Senate relies exclusively, if they do anything about voting rights, on an amendment to the Voting Rights Act. The second major decision of the term, the liberal decision, was United States versus Windsor, which was a 5-4 decision that declared the Defense of Marriage Act to be unconstitutional since it violated the Equal Protection Clause. The act created a federal, the Equal Protection Guarantee, since it was a federal law being challenged. The act created a federal definition of marriage that excluded same-sex marriages from the definition and allowed the federal government to refuse to recognize same-sex marriages, even if they were illegal, were entered into. And Kennedy wrote the majority opinion, striking down the law joined by the 4 liberals. In 2014, there were a few significant decisions, although not as significant as in the previous period where the court decided Shelby County and Windsor. They were a case called McCutcheon versus FEC, which was another of the Roberts Court decisions striking down campaign finance legislation. This time, a section of the Federal Election Campaign Act that imposed aggregate limits on the amount of contributions that an individual could make over a 2-year period to a national political party or a federal candidates committee. Roberts wrote for the plurality in striking down the limit. but Thomas didn't join the opinion since he didn't think it went far enough and conclude that all contribution limits were unconstitutional. But instead, the opinion took a more minimalist approach that the Chief Justice often uses. Another case, Riley versus California, was another Roberts opinion, this time for a unanimous court that held that the police are required to obtain a warrant in order to search the contents of a cell phone in a search that's incident to an arrest. The police are allowed to take some steps to preserve the contents of the phone from being wiped, but they cannot look at the contents until they get a warrant. The third case was another 5-4 decision, this time with an opinion by Kennedy, but this time he was joined by the conservatives and not the liberals. And the 4 liberals dissented. It was an establishment clause case that challenged the practice of beginning a town meeting with a prayer conducted by a volunteer member of the clergy, and the court upheld the town's right to begin meetings with a prayer. In 2015, the most important decision was Obergefell versus Hodges, decision that was the culmination of a series of cases with a majority opinion written by Justice Kennedy that protected same-sex relationships. Obergefell was, of course, the case where the court finally recognized the right to same-sex marriage and relied on both the equal protection and due process clauses to do so. It was another case where Kennedy, of course, wrote for the liberals. In this case, each of the 4 dissenters, the 4 conservative justices, wrote their own dissenting opinions. Obergefell is, of course, the kind of decision that would be impossible given the current composition of the Roberts Court. Another important case that same term addressed a very different subject, but it had the same voting lineup as Obergefell, and this time Justice Ginsburg wrote the majority opinion. And it was a case called Arizona State Legislature versus Arizona Independent Redistricting Commission. And it upheld the right of Arizona voters to take away from the state legislature the power to draw election districts and instead turn that authority over to an independent redistricting commission. It was one of the rare pro-democracy decisions from the Roberts Court, and it's not at all clear whether it will survive the current court. For most of the next 2 terms, the court had only 8 justices because Scalia had died, and he wasn't replaced until Gorsuch was confirmed towards the end of 2017, and therefore he didn't participate in most of the cases. The 3 most consequential decisions during that time period were a case called Evenwell versus Abbott, Whole Women's Health versus Hellerstedt, and Fisher versus the University of Texas. Evenwell was a unanimous decision. Justice Ginsburg wrote for the court. The case allowed states to use total population rather than just voting eligible population to draw legislative districts based on the equal protection principle of one person, one vote. The case didn't address the question of whether states were required to use total population, only that they were permitted to. The issue of whether total population was required to be used was raised in 2020 by Donald Trump's plan to exclude undocumented immigrants from the census numbers, but the Supreme Court never resolved the issue because of a delay in completing the census and the election of President Biden. Whole Women's Health was an abortion case involving 2 requirements: one, that doctors performing abortions have admitting privileges at a local hospital, and a second that abortion clinics have the same facilities as ambulatory surgical centers. Court struck down both provisions as creating undue burdens on the right to terminate a pregnancy without sufficient offsetting benefits to patients. Majority opinion was by Justice Breyer, who was joined by Kennedy, Ginsburg, Sotomayor, and Kagan. Roberts, Thomas, and Alito dissented. The final case was Fisher versus University of Texas, which upheld the right of the university. The court allowed the university to adopt an affirmative action admissions policy that satisfied the strict scrutiny test that the court had previously upheld in 2003 in Grutter versus Bollinger. It was a 4-3 decision because Kagan didn't participate. Presumably because of early involvement with the issue as Solicitor General. So the majority opinion was by Kennedy, joined by Ginsburg, Breyer, and Sotomayor. Affirmative action is another area where the current court might well change its position, but that has not happened so far. The term that began in 2017 still had the possibility of a liberal outcome if Kennedy joined the 4 liberals. The last time that would be true, but that 5-4 result was not actually what happened in any of the major cases. First major decision was Masterpiece Cake Shop. The case involving the baker who refused to bake a wedding cake for a same-sex couple was found to have violated Colorado's anti-discrimination law. The court, by a vote of 7-2, decided the case on very narrow grounds and found that the Civil Rights Commission had violated the baker's right to free exercise of religion because they had shown bias towards the baker based on his religion. Kennedy wrote that opinion, joined by Roberts, Breyer, Alito, Kagan, and Gorsuch, and only Ginsburg and Sotomayor dissented. Second important case was Carpenter versus United States. It was the second opinion written by Chief Justice Roberts involving the Fourth Amendment and access to cell phone information. Roberts is quite a believer in privacy of information you keep on your cell phone, undoubtedly thinking of what he has on his cell phone and how he wouldn't like the police to be able to look at it, maybe. I doubt there's anything scandalous there. Maybe some photos of his family that he otherwise doesn't allow to be made public. Anyway, the case was a 5-4 vote. It held that the government needs a warrant, generally speaking, to gain access to information about the physical location of a cell phone over a long period of time, even though the information was in the hands of a third party, the cell phone provider, which usually means the government doesn't need a warrant. Roberts was joined by the 4 liberals on the court, but not Justice Kennedy, who was one of the conservative dissenters. 2 other majority cases were one that upheld Trump's ban on travel to the U.S. by people from a number of countries, mainly countries with a large Muslim population, Trump versus Hawaii. Roberts wrote for the conservatives on the court, including Kennedy, deferring to the executive branch and rejecting an establishment clause claim that it was based on, the policy was based on anti-Muslim bias. And finally, there was the Janus decision, another 5-4 conservatives versus liberal decision. Justice Alito wrote for the court. And the court struck down something called an agency fee arrangement that required public employees who were not members of the public employee union, requiring that they pay something called a fair share fee to defray the costs of collective bargaining. And the decision to strike down the agency fee arrangement was once again based on the compelled expression doctrine that's become a favorite of conservatives. And it also relied on the view that money and speech are equivalent, so that being required to spend money is the equivalent of being required to speak. Kennedy then announced his retirement at the end of June 2018, and Kavanaugh had replaced him by early October. When the 2018 term began. And therefore, for that one term, Chief Justice Roberts became the man in the middle in terms of the ideological array of the justices. There were a number of important cases decided during that term, but the standout was probably Rucho versus Common Cause, the case in which the court ruled that challenges to partisan gerrymandering were political questions that the federal courts couldn't review. Roberts wrote the opinion, joined by the 4 conservatives. It was another anti-democracy decision by the Roberts Court. As Justice Kagan said at the end of her opinion, dissenting opinion in the case. Somewhere here I have that. She said, the practices challenged in these cases imperil our system of government. Part of the court's role in that system is to defend its foundations. None is more important than free and fair elections. With respect but deep sadness, I dissent. Another major case was the case involving the decision to add a citizenship question to the census form. The decision blocked the addition of the question on very narrow grounds, a Roberts specialty, and left open the possibility that the question could be added if the government identified a different reason for adding it, but that never happened. Roberts, of course, wrote the majority opinion, joined by the 4 liberal justices in the part of the decision that barred the question. A third major case involved separation of church and state under the Establishment Clause, and it upheld the placement of a World War I memorial in the shape of a large cross on public land, and the voting pattern was far from the typical one. Majority was by Justice Alito, and he was joined by Roberts and Breyer, Kagan, Kavanaugh, with Thomas and Gorsuch agreeing with the outcome, but writing separate concurring opinions, and only Ginsburg and Sotomayor dissenting. The reason for the lopsided vote was the decision was quite a narrow one and focused on only the issue of long-standing monuments and the fact that the cross was a symbol that had long been associated with World War I, rather than a broader decision changing the analysis used in Establishment Clause cases. The 2019 term had a significant number of cases involving a wide array of issues, and this is really the term where Roberts briefly took center stage. He was really in charge of the court during the 2019 term. This was the term in which the court decided that a huge array of important cases, decided that jury verdicts had to be unanimous. It interpreted Title VII as outlawing discrimination based on sexual orientation. There was a case in which Chief Justice Roberts was a critical vote in striking down a requirement that doctors performing abortions have admitting privileges at a local hospital, but he only concurred in that decision based on adherence to the whole women's health precedent. There were 2 cases involving subpoenas seeking Trump's tax records. Both of the opinions were written by Chief Justice Roberts, and he, I identified standards for lower courts to use to apply in these cases, but he remanded the cases back to the lower courts for the actual application. So again, kind of narrow casting the role of the Supreme Court, and several cases involving the religion clauses where religious interests won in each case. Roberts' control over the court was short-lived with the death of Justice Ginsburg and her replacement with Justice Barrett. And I'd say that the most important case of this term was Brnovich versus Democratic National Committee, the case that narrowly interpreted Section 2 of the Voting Rights Act and upheld 2 Arizona restrictions on voting. This was an opinion by Alito, joined by Roberts and the 4 other conservative justices, 6-3 decision. I think that the way I would characterize this term is a prologue. Not that much dramatic happened, but it's a prologue for the 2021 term and beyond. Next term already has the issues of guns and abortion back on the court's docket, and the docket isn't even half full. So that's everything, a lot, probably too much I had to say about the Roberts Court. Sorry, Judy.
No, that was great. Nothing to apologize for. I think it was really terrific. There's a question in chat from Karen and Jim, and they're wondering whether it'd be constitutional to order all Americans to get vaccinated in a pandemic. And the question in terms of the court, I guess, is, do you think such a case will even come to the court? And if so, any guesses or speculation on how they might decide? And your own view, of course, is welcome. Go ahead.
Okay. So sorry, that's I don't think that's me. So there were early cases, quite early cases in the history of the court where the court upheld mandatory vaccinations. At a time when we had other outbreaks of communicable diseases. But these were cases that were decided before the court. They weren't religion clause cases, so it was before the court had kind of developed its jurisprudence. But if the court were to follow those past precedents, then mandatory vaccinations would be constitutional as a response to a public health outbreak, like we're like now. I think it's very unlikely that it would be a federal mandate. I think it's more likely if there were to be a case, it would be a case challenging some kind of more local decision to require vaccinations, maybe at the state level, but maybe also, at the city or county level. And, that case might get to the court. The court decided quite a few cases involving pandemic restrictions. None of them had to do with mandatory vaccinations, but they did involve restrictions of various kinds. And they were all on the so-called shadow dockets. They weren't fully briefed and argued. But in the recent cases after Barrett joined the court struck down every single one of those as a violation of the religion clauses. So I think that if someone were to claim that getting a vaccine violated their freedom of religion, there's a pretty good chance that the current court would uphold the claim. I don't think there's any reason to believe that they would uphold the claim if it was just based on, I don't like vaccines, or I don't trust vaccines, or I'm a conservative Republican and I don't believe in vaccines, or I'm an anti-vaxxer. Because there's no fundamental right involved in any of those positions, in acting on any of those positions. It's not speech. You're allowed to speak out against vaccines, but it's different when you're talking about whether to get a vaccine. So in those cases, since there would be no fundamental right, that doesn't even need to be a fundamental right for the court to uphold such a policy. But I think there is some chance that if it was a religious objection, of course, that would mean that lots of people who now have other reasons for objecting might suddenly find religion, but there's nothing much we can do about that.
What about masks? Would that apply? Mask mandates?
I think it's unlikely that the court would strike down a mask mandate if there was obviously evidence that there was community spread of the pandemic, of COVID in any of its forms, for a couple of reasons. I think it's hard to argue that not wearing a mask is speech under the First Amendment, because it's symbolic speech under the First Amendment. And maybe it's intended to communicate a message, maybe, but it's unlikely to be understood that way. How do we know why someone is, walking in the street or in a store without a mask? I mean, it would require some, sign. I'm maskless because I'm a conservative Republican, or I support Donald Trump, and whatever. The other reason is that wearing a mask is something you only do from time to time. I mean, you're not required to wear a mask in your home. And at least in a series of cases involving clothing and public school students, the court has allowed, for instance, public schools to require uniforms of their students. Mm-hmm. And one of the reasons is that wearing a uniform is not, a classic example of speech or refusing to wear a uniform, but also because wearing a uniform only affects the student while they're in school. The minute they leave school, they could change into anything they want to. And a mask, it seems to me, is, that kind of temporary measure. So I don't know that it's, I would view it as a severe restriction on any kind of important right, even if you thought there was a right there to begin with that was fundamental, which I really don't. So, I'm guessing that would be upheld. Although there's been a great reluctance, to kind of, really strictly enforce any of these mandates, except employer-based mandates. That's what they want. Everyone, employers should do the dirty work instead of the government of requiring masks.
Yeah.
I would say the employer-based mandate seems to work because people don't want to lose their job by refusing to wear a mask.
Mm-hmm. So the quick question, and then we want to turn to what you're doing in the fall, and we also have a call on Joan. Do you think Roberts has lived up to his promise to be, quote, an umpire?
I was thinking about this morning about Roberts and, the difficulties of being Chief Justice throughout, this period when he has served. I think that, look, Roberts came with certain, strong views, but they were kind of limited to a few areas. Right. I mean, they weren't as global as Rehnquist or as Earl Warren. And maybe in those areas, you see signs of his pre-existing positions that surface in his opinions. But I think that he's been, pretty successful as chief during a time when, having that job is, close to impossible. I mean, he has really been a pretty minimalist judge. He's only decided what's absolutely necessary. He hasn't gone out of his way to reach broad opinions. He's He hasn't done what either Rehnquist or Warren did, which is to kind of put front and center ideology and moving the court in a particular direction whenever possible. Instead, he's, really tried to preserve the legitimacy of the institution. He sees that the court is under attack. And, that's just the last thing that he wants to happen. He just doesn't want the court to be considered the third political branch, just a bunch of political hacks. And there are so many forces that make it difficult for people to believe that that's not the case. And he's, been desperately trying to fight against that in whatever ways are available to him. So, I think that, his efforts are appreciated by the other justices who don't want that to happen either, no matter which wing of the court they represent. And he has, done the best job that anybody could in that circumstance.
Could you give us, I'm going to turn to Joan in a moment. Can you, Leora, give us a brief preview? The good news is that Leora will be back for 8 sessions. Again, our fall semester starts September 21st. So her first sessions will be on the 23rd for 8 weeks, and it's going to be somewhat different. So if you could tell us briefly about that, Leora.
So I'm going to teach a series of cases about the Bill of Rights, the first 10 amendments to the Constitution. I've looked at many of them individually, but this will be a more holistic view of the situation. And I'll look at the history of each of the amendments, as well as important cases that the court has decided interpreting each of the amendments. And so I won't obviously spend the same amount of time in each of the amendments, but we'll get through 1 through 10 during the 8 weeks.
That's great. Okay. So Joan Fabio, I think a lot of you know, is our treasurer. She's one of our officers, and thank God she's better at numbers than I am, as well as a lot of other things. So Joan, go ahead, please.
Leora, once again, thank you. It's just been absolutely fabulous. Just listening to you, it's so inspiring. I said to myself, why didn't I ever become a lawyer? So be it. But thank you again.
It's not too late.
Oh, yes, it is. We really do look forward to the fall semester. I especially love your classes. Really, thank you again for a wonderful summer.
Okay, and we all thank you.
I was just going to say thank everyone. This is really a great program.